Welcome, ladies and gentlemen, dear colleagues, to another episode of Dean's Talk. I'm pleased and honored to welcome my friend and colleague Bertil Emrah Oder, the Dean of Koç University Law School in Istanbul, who will talk about the current situation in Turkey with us tonight. Bertil Oder is among the finest constitutional minds of her country and beyond. She is a wonderful scholar, not only when it comes to constitutional law, but also to comparative aspects and constitutional theory. It's a delight to have you with us tonight, Bertil. Thank you so much for being here.
Thank you very much. Thank you very much.
If I may just go ahead and ask a question based on a quote, something I just came across the other day in The Economist when I did a little research for our talk in April 2017. It states that the Turks will vote in a referendum over whether to abandon their parliamentary system for an executive presidency. And The Economist goes on stating that the yes is likely, but far from certain. There is nothing wrong, it goes on saying, with the strong president. Turkey's new constitution goes too far, so the assessment goes. The country would end up, so it closes, with a 21st century sultan minimally curbed by parliament. A yes would condemn Turkey to the elected dictatorship of President Erdogan. So the question evidently is, after Erdogan came out as a winner of this referendum, is it indeed an elected dictatorship Turkey finds itself in today?
In case of Turkey, I would prefer to make a comparative analysis in the light of recent developments worldwide. We know that empirically studied by Luhrmann and Lindbergh, there is a third wave of autocratization, which means a gradual setback under a legal or more generally constitutional disguise. And it has become a phenomenon having a decisive impact on different constitutional jurisdictions. And under such a democratic decline, we observe some common features in entrenched constitutional democracies and electoral democracies. And these features can be focused on the decline of the media and freedom of expression, freedom of civil society, and to some extent, the rule of law. These are severely attacked areas. And in case of Turkey and in case of many other constitutional jurisdictions, another phenomenon is the augmentation of the executive. Although Turkey was classified as an electoral democracy that furthered her democratic consolidation under Europeanization process between 2001 and 2013, she has been marked as a category of democratic breakdown at present. In this respect, Turkey represents an incremental constitutional decline since 2013, and this is a year of Gezi Park protests against the government, and these protests have been massive protests of the civic society. However, in terms of the constitutional referendum and the presidential shift of Turkey, we have some sort of critical point as regards Turkey's autocratization, because the presidential shift provided by a constitutional amendment and constitutional referendum in 2017 has augmented the executive power in a very different way. When we consider the fact that in Turkish constitutional and political system, the parliament has always placed the central role, not only as a legislator, however, as a political agent, as the commonplace of political deliberation, we can be in a better position to understand the erosion of the parliament at present, because the parliamentary oversight has been diminished, even though on the paper in the constitutional norms there are specific guarantees for parliamentary procedures or in general parliamentary oversight. When we look at real operation of the things, we can easily come to the conclusion that Parliament is not very effective. Furthermore, in case of Turkey, we clearly observe a new phenomenon, a group of parties that can be defined very small parties and extreme parties. They have been also very strong right now because they have built up a new form of coalition at the parliament. This is not a governmental coalition, however, it is just a coalition at the parliament, because without the support of these small and extreme parties, I refer here to ultra-right parties, it is not possible for the ruling party to become effective at the parliament. When I take into account the augmentation of the executive in a very unprecedented manner in Turkey because of the constitutional referendum, and when I take into account this phenomenon, this new coalition opportunity for ultra-right parties, I can easily come to a conclusion that the democratic erosion of Turkey has undertaken a new path. And the horizontal constraints on the executive power has been decreased because of the lack of parliamentary oversight and because of the constitutional provisions guaranteeing a specific and autonomous space for the current president.
Many scholars, you among them, have warned that the structural modifications that came with this important constitutional amendment would weaken, of course, central state institutions. And some would argue that the current position Turkey finds itself in is due to this weakened position that these institutions find themselves in. However, I think on the other hand, we may not understand the referendum, its outcome, and the constitutional amendment without at least briefly touching upon the failed coup in 2016 and what happened in the aftermath. A state of emergency was declared in Turkey that lasted for about 2 years, to be only followed by a rather strict anti-terror legislation enacted in 2018. In the immediate aftermath of the failed coup, more than 2,000 judges were dismissed. Until 2018, if I have my numbers right, 180,000 civil servants have been dismissed, and they have been banned from re-entering public service for life. Also, the purge has severely had an impact of businesses considered having been sympathetic to those who initiated the coup, and also, of course, it has heavily affected the military. So is this quite singular and very strong reaction to this failed coup attempt also something to take into account, aside from the structural modification that has, of course, played a major role for the current state of affairs?
As regards removals from the public offices, we can make a distinction actually between the measures that are applied to the progressive segments of the society, including opponent journalists, including the academics, and including some intellectuals. And the judges and other public officers. When we look at to those removals and the methodology applied as regards the purge, particularly in respect of judges and public officers, I have to underline the fact that the current government has collaborated before the coup attempt a group of Islamists that are called as currently Fethullahist terrorist organization, and previously as the service movement in Turkish Hizmet movement, and this movement as an Islamic sector, Islamic community, has provided massive support with their public officers in the government, and they were also quite effective in the Turkish judiciary. Please let me explain how this has developed. In 2010, there was a very significant constitutional amendment in Turkey, and it has been perceived as a controversial constitutional amendment by progressive segments at that time, because this crucial constitutional amendment has reshaped the Turkish judiciary, including the apex courts and the lower courts, and particularly the Supreme Council of Judges and Prosecutors, which is the main authority that recruits judges and involved in the internal organization of the judiciary. And there was also a constitutional referendum at that time dealing with all those complex issues. And in the constitutional amendment package, we have also observed constitutional amendments as regards the constitutional court. Some of the amendments as regards the court were rather progressive, such as introduction of the individual application procedure, which is very similar to the German type of constitutional complaint, Verfassungsbeschwerde, and it has made a huge positive impact on Turkish judiciary and the protection of human rights in Turkey. However, in this constitutional amendment package, there were also regressive amendments for restructuring the constitutional court, besides the Supreme Council of Judges and Prosecutors. And after the constitutional amendment, there were again reform packages as regards other apex courts, and all those amendments have been criticized by the progressive constitutional scholarship and progressive segments of the society as court packing and court reshuffling attempts that may have a detrimental effect on the rule of law. And as soon as those constitutional amendments are implemented in Turkey, there were different types of elections for the Supreme Council of Judges and Prosecutors, and there were rumors that the Ministry of Justice was involved in the electoral process, even though it is forbidden. And the Ministry of Justice has also collaborated with the judges who have strong affiliations with the service movement or the Gülenists, and now they are called as the Fethullahist terrorist organization. And at that time, there were massive changes in the judiciary. My personal academic opinion as regards this issue can be summarized as follows. This crucial point that has provided intense interventions into the rule of law and the Turkish judiciary had a crucial impact. And as regards changing the structure, changing the culture of Turkish judiciary, and it has also introduced a massive politicization in the judiciary because of this collaboration of two groups within the government. However, after 2010 constitutional amendments and the elections and reappointments in the Turkish judiciary on the ground of this type of how should I say that, a dirty collaboration in political sense, we have observed some sort of a tension between these two groups within the government. And we have also witnessed that this collaboration or political coalition between the Gülenists and the current party, AK Party, the ruling party, has collapsed. And after these developments, there was also a huge debate within the judiciary, and there were again amendments, different types of reform packages to eliminate the judges that are appointed on the basis of the previous coalition. And shortly after this debate, we have also witnessed the coup attempt, and again massive purges in the judiciary and in the other public offices. However, we have also witnessed something very different and very significant after the coup attempt. Not only the judges who have strong affiliations to the previous Gülenist movement, but also the public officers, particularly scholars in state universities and in foundation universities, have been removed from their offices. Most of them have been removed from their offices because they have signed a petition which has criticized the government because of the implementation of anti-terrorism legislation in Turkey, because of the curfews that are implemented in southern eastern regions of Turkey. Approximately 2,000 academics are removed from their offices, and they have lost their jobs, and under different international schemes, including the Scholars at Risk programs, they fled the country, and some of them have applied to the courts. And in the meantime, the government has established an investigation committee as regards those issues. And shortly after the coup attempt, we have also witnessed a massive purge and a crackdown conducted against the journalists. When you check the Journalism at Risk platform of the Council of Europe, you can easily identify the high numbers in Turkey as regards jailed journalists. In other words, it seems that the government has used its power in a very abusive manner, not only against the group who has been considered as an actor behind the coup attempt, but against the progressive segments of society who have nothing to do with the involvement in the coup attempt, including the progressive academics, progressive journalists, and intellectuals. And in the meantime, the anti-terrorism legislation has been tightened, and there were other amendments in the relevant legislation having a huge impact on freedom of association, freedom of expression. And recently, the government has passed a new legislation, for example, as regards the bar associations. And this legislation aims at establishing new bar associations in cities to control the bar associations, because the majority of the bar associations are not friends of the current government. And in terms of human rights protection, in terms of allocating their funds for legal aid, and in terms of their political role in the society, they do not support the government. This is a brief summary, of course, what has happened in Turkey. And under current framework, we witnessed that not only the presidential shift, However, also the decline of the quality of democracy in terms of deinstitutionalization and in terms of autocratization can be clearly observed.
Thank you very much for this assessment. We have touched upon so many topics that I would like to cover with you. Before proceeding, I would, of course, like to re-emphasize that our audience is invited at any point to join the conversation by simply using the chat function of our meeting here. So if you have any question that you would like to ask, please just go ahead and ask it, and I will pick it up along as we move further into our conversation. Coming back to the position of courts, we met 2 weeks ago virtually at a Zoom conference that was scheduled to take place here in Graz, but then, of course, couldn't take place on site. And you presented a marvelous paper on the position and the difficult position that the Constitutional Court finds itself in at this point of time due to various reasons. And I was quite struck by the fact that only recently, I think in October, 2 lower courts decided to disregard 2 rulings of the Constitutional Court, simply not following the court's orders. Some scholars observe that at least parts of the judiciary in Turkey may find themselves at war with each other. Is that a correct assessment? And what state is the judiciary as the keeper of the rule of law in at this moment?
At present, the Constitutional Court plays actually the key role since it doesn't represent the features of a typical subservient court, and that is the reason its judicial behavior deserves also attention to understand the role of judiciary in Turkey and probably under other electoral autocracies. The Constitutional Court's stances challenges, in fact, the presumption that the constitutional review under democratic breakdown has been always subservient, always faithful to the autocratic regime. The constitutional judges in Turkey are appointed by the president and the parliament, and they have both quotas, and there are also nominations of the apex courts, the Higher Education Council, and Turkish Bar Association. In other words, they are also part of the election process. And at present, 14 of 15 constitutional judges are appointed by the elite affiliated to the current ruling party, and 5 out of 15 judges are appointed by the President Erdogan. And although majority of the current judges are appointed by the ruling AK Party elite, there is a criticism of the government towards the court. And this can surprisingly take sometimes the form of direct threats to its jurisdiction or immediate assault on the judges. And we also observe the criticism of the opponents, and they blame the court being very weak or representing some sort of sham resistance against the autocratic policies. And I have emphasized that the constitutional amendment in 2010, this controversial constitutional amendment, has introduced the individual application procedure, which is similar to German type of Verfassungsbeschwerde, and it has provided a supportive mechanism for human rights protection. It seems that this threatens the stability of autocratization by creating an uncertainty for the current regime. The court comes to the focus as a power broker, and it also becomes a very popular agent through the individual application case law due to the low commitments of public authorities as well as the lower courts to the human rights. And in this respect, we clearly observe that there is a massive politicization of the lower judiciary, and the low quality of justice is a very serious issue for the newly appointed judges, because after the removal of the judges who have been claimed as the supporters of the Gülenist or service movement, that is called the federalized terrorist organization right now, there were new appointments, there were new recruitments. And this new judiciary has not any chance to improve itself in terms of taking the advantage of different types of in-service training for the human rights protection, and it seems that a part of this new judiciary has no strong commitment to the constitutional democracy, to the rule of law, but a very strong commitment to the priorities of governmental circles. The lower judges and prosecutors have, of course, constitutional guarantees, but this does not extend, for example, to the geographical tenure or similar arrangements. And under current course of events, the lower judiciary seems the weakest chain of the system, and particularly the judicial cliques affiliated to the governmental cliques seem to play a significant role in mega politics and politically sensitive cases. The lower judiciary is under the control of the Council of Judges and Prosecutors. In case of the Constitutional Court, or in case of the Court of Appeals, or in case of Turkish Conseil d'Etat, the highest administrative court, we do not observe such a phenomenon, because the Council of Judges and Prosecutors cannot control the Supreme Judiciary, and the Constitutional Court seems the most powerful one among the apex courts. However, the individual application procedure has meant also a shift of power both from the lower courts and other apex courts. And in this sense, there is also a tension between the Court of Appeals and the Constitutional Court, even though it is not very strong compared to the tension between the lower courts and the Constitutional Court. Finally, I should also underline a very significant point. The resistance of the lower courts against the Constitutional Court is also a totally new phenomenon in Turkish political and judicial history. We have never witnessed something like that. This is a totally unusual and extraordinary judicial behavior of the lower judiciary, and that is the reason we can also come to a conclusion that the politicization of the lower judiciary has reached to a very high level under current course of events in Turkey.
Thank you very much for this assessment. Some scholars, and you among them, have argued that the courts also, and the criminal courts in particular, are being used as an instrument of prosecuting members of either the opposition, human rights activists, and so on and so forth. This issue, in my understanding, somewhat culminated in the trial of Osman, the businessman who has been held in detention for quite a while now, even though urgent calls for his release have been issued by the Council of Europe following a judgment of the European Court of Human Rights and so on and so forth. Mr. Kavala, in my understanding, was first prosecuted during the events, or in the aftermath of the events of Gezi Park, and then thereafter, after having been acquitted, he was detained yet another time and is held at this very moment awaiting trial. He's just one figure, but a powerful symbol at this point of time. How, and you called it autocratic legalism, may make use of the instruments of criminal law in order to punish political opponents.
Yes, actually, particularly in case of Osman Kavala, that has been brought before the Constitutional Court and also the European Court of Human Rights, we clearly observe the use of lower judiciary as the pawn of the regime. And the Kavala case is just an emblematic case in this respect. And even though this case has been brought before the Constitutional Court, in a majority ruling, the court has refused the individual application as regards long pre-trial detentions of Osman Kavala. And I can also remind in this respect that as soon as the case as regards the Gezi Park has been finalized by the relevant court in favor of Kavala, and Kavala has been released, on the very same day, the Kavala has been rearrested on the ground of different allegations. Now there is an ongoing trial against him on the basis of his involvement in the coup attempt in 2016. This is an emblematic case, how the human rights defenders can be oppressed by using the lower judiciary. And in this respect, the European Court of Human Rights has declared the violation in case in respect of a human rights defender by referring very significantly to the ulterior purpose doctrine, because the Kavala case is also a perfect example of stigmatization and conducting different types of smear campaigns against human rights defenders. There was a very similar pattern, in fact, as regards the cases launched against the academics for peace, and against in some of the journalism cases, particularly in Cumhuriyet trials. This is the major journalism case in Turkey. Again, we observe a very similar pattern. A few days ago, the government has declared that it will launch a new democratization or reform package for strengthening judiciary in Turkey, for enhancing the rule of law. And prominent figures in the ruling party have shared publicly that they will launch a road map in terms of re-democratization in Turkey. However, under current circumstances and under current decline, it is hardly believable that it will be a successful attempt. And the government has also sent very warm messages to the EU in this respect. At present, there are no proposals, of course, and there is an ongoing debate, particularly as regards Kavala case. Some of the cases as regards journalists, for example, the case of Cumhuriyet journalist is pending before the Court of Appeals, and this group of journalists has won the case before the European Court of Human Rights. However, the European Court of Human Rights has not declared the application of the ulterior purpose doctrine as regards the Cumhuriyet trials. As regards the academics for peace cases, the Constitutional Court hopefully decided in favor of the academics, and this has been a huge progress in terms of protection of the freedom of expression.
I would like to come back to that in an instant. In the meantime, we've had two questions in our chat. One asked by Professor Benedek, our emeritus professor of international law, and he follows up on what you said about the important role the Bar Association plays and the way it is not considered typically to be an ally of the current government. At this moment, plans are being made or perhaps even undertaken to pack the bar associations with more friendly faces and to shift the balance of power when it comes to this field of the law. Do you have any thoughts on that?
Yeah, this legislative amendment is crucial, and Turkish bar associations from almost all cities have organized a march to Ankara, and all highways to Ankara were fully occupied with the lawyers, despite the pandemic, actually. And they have also occupied the parliament, and they have challenged the relevant legislation. This new legislation is crucial because it provides the multiplication of the bar associations. For example, in Istanbul, there is only one bar association, or in Ankara or in Izmir, there is only one bar association. Now we will be having 3, 4, 5 bar associations, which may be in line with the governmental policies. And strikingly, it was very difficult to implement the relevant legislative amendment because, as you may imagine, the legislation, the new legislation, has provided a threshold of signatories to establish a new bar association. However, the friends of the government who work as the practicing lawyers could not reach the threshold in most of the cities. And this is also a very interesting phenomenon. In Ankara and in Istanbul, there were last-minute applications because of this threshold issue. Now, it seems that there are only very small groups of practicing lawyers who would like to collaborate with the government or who would like to be seen as the friends of the government. However, this happens right now in Turkey. When I look at to the general climate of bar associations, the overwhelming majority of the practicing lawyers are affiliated with the autonomous bar associations, which do not want to serve to the aims of the government. Let me say also something about the Europeanization effect in Turkey. Unfortunately, as regards the overhaul of judiciary, particularly the amendments in 2010, the Europeanization impact has not been very successful. The EU Commission, as well as the Venice Commission, could not understand the dynamics of Turkey, particularly the political dynamics and cultural dynamics of Turkish judiciary, and they have supported the constitutional amendments in 2010. Of course, I do not mean the constitutional amendments as regards the presidential shift. Now, when I look at to the very recent Turkey report of the EU Commission, there is a very strong criticism of EU Commission, and it underlines, of course, the massive backsliding in Turkey in terms of democratization, and hopefully it has a very critical stance as regards governmental interferences in the bar associations and in other severe violations of human rights in Turkey.
Thank you so much. Well, let's come back to this issue of the situation or the deterioration, let's call it by its name, of human and fundamental rights in Turkey continued over the last few years. A particularly interesting, even if particularly disturbing example evidently concerns, and you referred to it a couple of times now, the state of freedom of expression at this point of time in Turkey. I found a very interesting, even if again disturbing number in a news report of last year that Turkey, China, Egypt, Eritrea, and Saudi Arabia account for 70% of all reporters imprisoned that year, mostly for infractions against the regime. Now, let's assume that this number is correct, and we don't know how large Turkey's share of that number is, evidently. However, we do know it is significant. Of course, what does this tell about the government's position when it comes to free speech and to the established media? This is the first part of the question. The second part of the question is also the government is strong stand against social media and its users. In my understanding, this July, a new law was enacted that would significantly disinhibit the possibilities of social media use. If not, content would be removed rather quickly. If not, responsible personnel would be named specifically for Turkey, and so on and so forth. All this following the previous ban of Wikipedia in Turkey in 2019 paints a picture that overall doesn't seem too bright when it comes to freedom of expression.
I generally think that the freedom of expression and its systematic violations is a featuring element of the third wave autocratization. And in case of Turkey in 80s, particularly after the coup attempt in 1980, Turkey has a very bad record of severe human rights violations in terms of prohibition of torture, in terms of violation of right to life, in terms of forced disappearances, and so on. And in this sense, Turkey has unfortunately contributed to the development of the case of the European Court of Human Rights. Under current democratic decline, we witness a different type of human rights violations pattern, which is depicted with the violations of the freedom of expression and the journalism issue, particularly free media, is the key factor, and it is at the target of the government. Not only the oppression applied in respect of opponent journalists, but also in terms of changing the economic structure of Turkish mainstream media. Turkish government has adopted different types of measures against media conglomerates, and it has changed the structure, particularly the mainstream, the structure of the mainstream media. Now, of course, we have opponents or the voice of opposition in the media. However, particularly in different types of alternative channels using social media. For example, Mediascope is the leading opposition channel, gathering different types of experts. However, it is not a conventional type of media, using different channels such as YouTube and different types of streaming on social media platforms. There are also various alternative channels and alternative newspapers. In other words, since the government has controlled the conventional media by using different tools and infrastructures and modalities, the social media has become a very significant venue to become vocal among different types of societal circles. This is the reason that the government would like to intervene. Social network platforms would like to change the infrastructure, would like to make new rules and frameworks or regulations for the social media. And very recently, in July, the parliament has passed a legislation that has been perceived as a rapid response of interferences in the social media. Of course, there has been a regulatory framework for social network platforms in Turkey. However, it has changed this regulatory framework by requiring the appointment of a local representative for social media platforms such as Facebook, Twitter, and so on. And in case the local representative is not appointed, there is a regulatory framework which may be perceived as a gradual sanctioning process, even though it is not in line with the principle of proportionality. The principle of proportionality is a constitutional tenet in case of Turkey, which is to be interpreted in line with the case of the European Court of Human Rights. However, the new legislation imposes severe fines, severe administrative fines in terms of monetary fines, and there is also a threat of reduction of the bandwidth as regards social media platforms. Then we consider that the social media, including alternative channels, and including an interaction, including the role of the social media as a venue of democratic deliberation, this is a threat against the democratic society, and of course against the freedom of expression and against the citizenry in broader sense.
I have two more questions now in the chat that concern Turkey's somewhat complicated relationship with Europe in general and the European Union in particular. I would like to come back to those at the end of our chat. At this point of time, I'd be rather curious, or at least to address the elephant in the room. Everybody nowadays, and this is the reason why we don't have you here in Graz at the moment, but we have to use this questionable tool of communication at the moment, is of course concerned with the pandemic and how different states would react to it differently. It has been my understanding that in the beginning, Turkey has done quite well in tackling the challenges that the pandemic raised. This also has been due, in my understanding, is quite well endowed public healthcare system, and the great amount of intense care beds provided per 100,000 citizens, which seem to be 4 times the number as those facilities would provide in Italy or France, for example. But nowadays it doesn't seem, or the situation doesn't seem that bright any longer. Curfews have been reintroduced and so on and so forth. So maybe you could tell us a bit more about that, and perhaps you could also, because this is of course a great source of worry for many observers, tell us how Turkey's fighting the pandemic does play together with all the other issues that we just discussed. Because evidently in Europe, at least some would consider government's tendencies to fight the pandemic effectively to be somewhat repressive, at least. If we consider this against the backdrop of what you already told us in the last 45 minutes, does this serve as an additional catalyst in this context, or does it simply run along the lines without having much to do with the general state that Turkey finds itself in at this point?
Yes, compared to the countries in Balkans and Mediterranean region, Turkey has faced the pandemic relatively late. Therefore, the public authorities had time to follow the developments, particularly in Italy and Spain. This has enabled not only the government, but also the metropolitan municipalities involved in the crisis management to shape their responses. At present, the mayors of metropolitan municipalities that represent the highest population of Turkey, such as Istanbul, Izmir, Ankara, Mersin, Adana, are the politicians of the main opposition party, and they still stand out with their very strategic and planned approach, considering the vulnerable groups that need, as you may imagine, a special treatment in a very successful manner. And these are the groups that live under extreme poverty due to COVID-19 pressure because of the economic situation. Turkish Roma groups. There is a population in Turkey as regards Roma, illegal migrants and homeless people. However, the metropolitan municipalities are obliged to conduct their operations under the disputable governmental inferences, such as the blockage of their accounts as to the coronavirus donations. However, both Ankara and Istanbul mayors have launched a legal action against the governmental action based on a peculiar circular blocking them from holding donation campaigns during the coronavirus. In fact, the law on municipalities gives the explicit authority to organize social aid campaigns to meet the needs of the society. And despite the governmental blockage, in the recent polls, there is a remarkable increase in the public confidence of Mayor of Istanbul and Mayor of Ankara. And they are the two rising political stars of local democracy, and domestic actors of Turkish political struggles as progressive actors of our current democratic life. And against the backdrop of Turkey's democratic decline and the augmentation of the presidential power after the constitutional amendments in 2017, the local government seems to have played the major role to resist and challenge the autocratic measures and all kinds of democratic deficits of the current government in the field of social benefit programs. The metropolitan cities have become the main competitors of the government with their very smart policies, close to the citizens, allocation of different funds to the public interest in a very reliable manner, and increasing the public engagement and developing rapid response programs. And this local dynamic is totally new in Turkey's political context, particularly under Turkey's heavily centralized model of governance. Here, I have to also remind the fact that Turkey is a welfare state, and welfare state is a constitutional principle, and it is an irrevocable constitutional principle. After 1960, Turkey has adopted welfare state as a constitutional policy and a constitutional tenet. And when I look at to the success of the current government, I have to also underline the recent healthcare system reforms. In Turkey now, we have approximately 42,000 intensive care beds. And this number is higher than Italy, France, Spain, and the United States. And the schools of medicine and health education in Turkey have been traditionally very well structured, and Turkey's research performance in health sciences, in STEM areas, and Turkey's healthcare performance have been always very remarkable. And Turkey's current populist autocracy has gained the public support by developing social policy and reforming the health system, which is called the Health Transformation Program, securing the universal health care for all citizens under the title of general health insurance, and the family medicine was supported, popularized, organized with a computerized system. The last interesting point could be the role of the Minister of Health. The Minister of Health is another rising star in Turkey. He has gained the confidence of the public opinion as well as the confidence of the main opposition party with his open, evidence-based, informative and regular communication despite some deficiencies in recent times. And this has provided, of course, an advantage for the government. However, when I look at the recent statistics as regards the COVID-19 cases in Turkey, there is a rapid rise, and there were also problems of transparency for sharing the relevant data. A few days ago, the Minister of Health has made an announcement, and he has again adopted a very transparent approach. However, according to the recent polls, referring to different indicators, including the oppression of the civic society, including the high inflation rates, because of the economic situation, there is also a rapid decrease at the advantage of the government. And according to a very recent poll, for the first time in the last 15 years, the governmental circles have lost the confidence of the general public.
That's an interesting feature. Let me just briefly follow up on that, because evidently Turkey's economy has been somewhat in turmoil over the last, let's say, 15 years. It has just been about to bounce back in 2020. And Al Jazeera predicts that it will continue to do so in the last quarter of this year, at least reinstating somewhat robust growth. However, some may argue that in this time of crisis, the pandemic has hit particularly hard. So would you say, or may I infer correctly from your statement that, of course, the general economic situation may add to that?
Yes, exactly. Yes. Yes, of course. I totally agree with you. And when I take into account the rise of the cases and the current lockdowns, now we have adopted another lockdown policy, particularly at the weekends. There will be total lockdowns. It will have a huge detrimental effect on the economy. I have realized there is a question in the chat box. This is quite interesting as regards state of emergency. May I also answer this question?
I was about to ask you if we could make good use of your time for perhaps 5 minutes so we can address additionally this question in the chat.
Okay.
So I kindly ask you to proceed.
Okay. Although the dangerous contagious disease, like the pandemic, is predefined as an explicit legal ground of emergency in the Constitution of Turkey, the government has not favored the application of emergency regime. The majority of restrictive and suspension measures have been adopted by referring to the ordinary statutory legislation, but in a gradual manner and under the guidance of the ad hoc scientific council established again by the Ministry of Health for COVID-19 crisis. And this scientific council has played a very significant role. Announcing measures according to the curve of infected people or prone zones, the government has predominantly referred to the law on the protection of public health. However, this law is a very, very old statutory ground that dates to the years of early Republican modernization, namely 30s. And the relevant restrictive and suspension measures were not explicitly predefined in this very old legislation. It is totally outdated, but in the law on the emergency regime. Since the Turkish constitutional system makes a distinction between the suspension of the rights and the restriction of the rights, this is a problem. And the excessive forms of interventions have been implemented under a non-emergency regime. And this has also created a legal debate of unconstitutionality in Turkey. However, when I take into account the low performance of Turkey under emergency regimes declared on the ground of terrorism, this situation, the current situation, is something more manageable and more in line with the human rights protection in Turkey. One final point can be deemed also very interesting. I can also note that the presidential system allows the announcement of presidential decrees. However, the president has not used this power extensively for operational matters such as lockdowns and similar issues for the pandemic. All those measures, all those restrictive or implementing measures, all those crucial or nasty measures are undertaken by the Ministry of Interior. This is also quite interesting, so that the president has tried to keep his own popularity by transferring the nasty issues to the Ministry of Interior. And this is also quite unique in case of Turkey.
Thank you so much, Bertil. Two questions still await in the chat to be answered, and for quite some time now. So I would like to close with these two, if you don't mind. One asked by Anita Ziegerhofer, professor of legal history here at Graz, and she's curious as to your assessment of the EU-Turkey agreement of 2016 addressing the then current refugee crisis. And then Weistin Schulef-Steindl would ask you for a general outlook of how Turkey finds itself or positions itself when it comes to the European Union. I was also curious in both questions, and my research prior to this conversation pointed me evidently to the Commission's 2020 report on Turkey. And if I may quote on the former issue, it was quite interesting. The Commission would state that in the area of migration and asylum policy, Turkey made some progress. Says so generously. Throughout 2019, Turkey was committed to the implementation of the EU-Turkey Statement of March 2016 and played, this is rather euphemistically put, a key role in ensuring effective management of migratory flows along the Eastern Mediterranean route. The subtext of this, in my understanding, would go like this. The Commission does realize that at least when it comes to migration, it desperately, or Europe, the European Union, desperately needs Turkish support and collaboration. And of course, against that backdrop, the European Commission or the European Union in general may find that they may in much greater need of Turkey's overall political support and partnership than has been in the center of political deliberations in Europe over the past couple of years. On the other hand, as Vice-Dean Schulz-Steidl points out, maybe Turkey itself undergoes a reorientation towards the European Union, at least in some political circles. May I have your assessment when it comes to these 2 points?
This is just a very difficult position when I try to look at from European perspective. When I try to look at from perspective of Turkey's civic society, and particularly human rights defenders and other progressive groups, again, this is just a very dilemmatic position. As regards the refugee agreement, Turkish progressive segments have criticized the EU that this has been an unethical bargaining that has enhanced, of course, the power of the government. When I look at to the domestic politics and debates, it is obvious that the president and the ruling party has taken the advantage of the weak position of the EU. And before the negotiations and during the negotiations, there were some visits to Turkey, and it also gave the impression that the EU, and particularly Germany, Merkel has also visited Turkey, both have supported Erdogan government. And this has also created a huge disappointment in the civic society. They have felt truly alone, since they thought that the refugee deal has provided an additional power of bargaining for the current ruling party, and this is partly true, unfortunately. However, the European Parliament has played a very positive role as regards developing new plans and allocation of funds for the civic society. 2 years ago, the European Parliament has released a resolution and advised the Commission that it develops specific funds and programs for rural areas and some specific support programs for developing the capacity of the civic society, with a particular emphasis on freedom of expression and freedom of association. And currently there are ongoing projects in Turkey. Instead of fully supporting the bureaucratic activities or the education of judges or similar programs, now there is another path for the civic society to take the advantage of different funds for strengthening its capacity and its own knowledge. As regards the refugee deal, I am a little bit confused. I truly understand that a deal is necessary in such issues. However, the main challenge, in my opinion, is the very strong focus of the EU on the refugee deal, instead of the Europeanization dynamic in Turkey, instead of developing its own normative power in Turkey. The EU has fully focused on the refugee deal, and I think that it was just a mistake. I mean, such a full focus on the refugee deal, or a sole focus on the refugee deal, has been a mistake. is there anything that I haven't answered? Excuse me.
Well, we may well put it bluntly and say the EU is not only focused mainly on the refugee deal, but it is mainly focused on itself and the self-absorbed European Union in this context. I mean, to be honest, will not be too beneficial when it comes to civic society in Turkey and those who would actually engage in further Europeanization in Turkey to a larger extent. And of course, this is something that the European Union has brought on itself, basically, to some extent. Dear Bertil, it was a pleasure talking to you, and I would like to thank you very much for having spent so much time with us. I have not enjoyed, frankly, everything that you said, but I have very much enjoyed talking to you, and I'm very much looking forward to welcoming you on site here in Graz as soon as this is possible. I would like to thank all those in the audience today and all those asking these thoughtful questions that have been so important in our conversation. I think we can continue our conversation for a couple of more hours, but as I understand it, it's way beyond dinner time in Istanbul, and dinner is well deserved after such a long day. So Bertil, once again, thank you so much for being with us tonight, and I hope to welcome you here in Graz anytime soon.
I thank you very much for the very kind invitation and for this very insightful conversation. I thank you very much for the interest of the all participants, and may I also say thank you in German as a final word if we have enough time.
As you are fluent in German, you can address the audience as long as you want. It's your dinner that's at stake.
Okay. Thank you so much again. Und letztlich bedanke ich mich bei Ihnen, dass Sie mir die Gelegenheit geben, in dieser Reihe von Dienstag meinen Standpunkt darzulegen. Und herzlichen Dank für die Interesse der allen Teilnehmer und Zuschauer und Zuhörer. Dankeschön.
Ja, dir vielen herzlichen Dank. Einen schönen Abend nach Istanbul. Dienstag is going to take a break because there's a public holiday in Austria on December the 8th. We will continue our series on December 15 with my dear friend and colleague Yannick Rosenay, who will talk with us about the situation in Israel. I hope that many of you will be in a position to join our conversation, and I wish all of you good night. Thank you for being with us this time. See you next time around. Bertil, again, thank you so much. Good night.
Bye-bye. Bye-bye.